Less than 2 weeks ago, I posted a video to my YouTube channel about the law being paywalled. Fortunately, in the case in question, ASTM v. Upcodes, the court found that the law should be publicly accessible and anyone who took the law and reposted it was engaging in fair use. Which is weird, because why is the law copyrighted to begin with? We're talking about things like building and electrical codes. There are standards made by private organizations, and they make their money selling those standards to companies. Sometimes, when a government wants to pass building codes, they do it by reference, meaning they just say that this standard is now the law and must be followed by everyone. And now, those standards bodies are pooping their panties because the courts are saying that the law is fair use, or sometimes even public domain. But it should be! These are the laws that affect you and me, that we all have to follow, and that we have every right to know about and have a copy of, and go and complain to our lawmakers about if we don't like them. So in response to this and other court decisions, these companies lobbied Congress to create the Pro-Codes Act, which purports to be about protecting and enhancing public access to codes, but is really about preserving their copyrights. And you can hear all about it in the committee meeting they held this week.
These how-to manuals, which are included by reference in many laws, but ultimately are far more than simply statements of fact for the law. Many say because they are included by reference by cities and others, that somehow that diminishes their legitimate copyright.
It's not that it diminishes their copyright, it's that the law should be public domain.
There are those who will argue that if once something is fact and everyone knows it, it's not copyrightable.
Yeah, including the Supreme Court.
For those like me who love to cook, does that mean that when Betty Crocker tells you how to make cookies and she gives a set of ingredients, that somehow the Betty Crocker book should not be copyrighted?
Yes, that's exactly what it means. The copyrightable aspects of a cookbook, as long established by the courts, are things like the layout, pictures, accompanying copy, etc. But the ingredients and instructions themselves are fact-based and not copyrightable. Gotta love it when their own analogies expose their incredible ignorance.
Some point to the Supreme Court's Georgia versus publicresource.org decision and say, quote, that no one owns the law.
They were actually quoting Wheaton v. Peters from 1834 when they said that. And they were quoting Nash v. Lathrop from 1886 when they said, quote, the animating principle behind this rule is that no one can own the law. Every citizen is presumed to know the law, and it needs no argument to show that all should have free access to its contents. This is an old, long-standing principle. That is being threatened by the Pro-Codes Act.
Others point out that SDOs fund their work by selling their copyrighted material to experts. Multiple circuit court decisions have found that publication of codes incorporated by reference is fair use. So if we want to ensure that SDOs retain their copyright, legislation is necessary.
Oh, shut up, Hank. Why are you even still in Congress? You remember Hank Johnson, right? He's the one who said that if Guam's population grew too high, the island would be in danger of capsizing. He's as stupid as they come. Let's listen to one of their 3 industry mouthpieces they brought in to lob softball questions to. This first one is James Pauley, President and CEO of the National Fire Protection Association.
The need for this system, it's accelerating. From devastating wildfires to new risk from lithium-ion batteries, the NFPA is developing standards to address challenges that didn't exist just 10 years ago.
Yep, it's all fear-mongering from the word go. If we don't give up our full public domain access to the law, we'll all be killed by wildfires and exploding batteries. Think I'm exaggerating? Just listen.
If you take away copyright protection, the funding disappears, and with it, the system that has made Americans safer for more than a century. That's where the Pro-Codes Act comes in. This bipartisan bill reaffirms the copyright protections for standards incorporated by reference while promoting transparency for the public.
Yeah, I think we all know what transparency means. we get read-only access to heavily redacted PDFs that we can't even search. And if you so much as make a copy of it, you're infringing, because remember, what they're opposing is the courts considering the republication of the law not public domain, but fair use. Fair use is what they're complaining about, and fair use is what they want to eliminate.
But codes and standards are not the law.
Unless they're passed into law, which is exactly the case we're talking about.
The current system is like a dam, and the court decisions are putting cracks in that dam. And those of us downstream, right now, it's just our feet that are wet. But if Congress waits for the dam to break, we can't come back from this.
You know, it occurs to me that when it comes to the law that people and businesses have to follow, how you stay afloat as a business is not our problem.
Every year, the standards that NFPA and organizations like us develop prevent tragedies that no one will ever hear about. Fires that don't start, buildings that don't collapse, families that come home safe. That's what we stand to lose if Congress doesn't act.
All right, enough of that crap. They did have a fourth witness who was a voice of reason. It was supposed to be 2 for and 2 against, but it really wasn't. Jonathan Band, principal of Policy Bandwidth, a law firm specializing in IP and internet policy, made no bones about it.
ProCodes is unconstitutional. Allowing a private entity exclusive ownership of the law would run contrary to the rights of free expression and due process. But this public access requirement is insufficient to cure the bill's constitutional infirmity. The bill does not require the full text of the public access version to be searchable, downloadable, or reproducible. Also, the Act would codify existing restrictive practices of SDOs that require users to create an account and agree to terms of service in order to access the material online.
And remember, that's to access the laws that affect the lives of you and me.
The basic premise of ProCodes is that without the incentive provided by copyright, SDOs would not undertake the costly standard development process. This premise is incorrect. In the vast majority of cases, industry participants have an economic incentive to participate in the development of standards. Often, SDOs lobby government entities to adopt their standards as law. In the absence of copyright protection, SDOs would still develop standards and then request government entities to adopt them as regulations.
But he wasn't just explaining why it was bad, he came in with his own solution.
Direct incorporation is a better way to address this issue. IBR is an analog-era solution that was necessary when voluminous standards were available only in printed publications that were expensive to produce. Now that standards can be made available digitally, it would be more efficient and effective to require government agencies to incorporate standards directly into codes.
Yeah, and that way they'd just be available on your state's website. But they don't want a solution, they just want their copyrights. So I guess the thing to do now is fearmonger about AI.
AI, forcing people to put their standards on the web under the Anthropic decision, gives the agent the ability to read it and exposes us to all kinds of AI dangers, right?
So if the law is publicly available, then the AIs will find it. And that's bad because, right? Yeah, I think you need to be more explicit in step 2. By the way, speaking of Anthropic, check out this bit from the bill's author, Deborah Ross.
Well, AI is wonderful when it produces a public good. But when you're going to make money off of it, no can do. And that's why Anthropic lost its lawsuit.
Anthropic has not lost any of its lawsuits, you lying sack of shit! In fact, they won hands down that exactly that, taking public information and making money off of it, was absolutely fair use, quote, spectacularly so. Sorry, let me pop a blood pressure pill. Listen to ISO while I do.
I'll go back to Napster. You know, in Napster, the recording industry didn't have to prove they were going out of business, although they sometimes alleged that it would kill them. They only had to show a violation of the copyright.
Right, but the difference here is we're talking about the law.
No, wait a second. We already went through this in detail.
Yeah, don't pester us with facts, Band. The only other expression in opposition was from Zoe Lofgren.
The Supreme Court in Georgia v. Pro found that this is fair use. Justice Roberts said no one can own the law. Justice Thomas said statutes and regulations cannot be copyrighted. And so I think the law is clear. In the amicus brief in ASTM versus Public Resources, the NAACP noted that, and this is a quote, without the information contained within the technical standards at issue, Black and low-income communities are fighting blind against landlords and other powerful, well-resourced adversaries. For these communities, access to the standards is access to justice.
Wow, she actually managed to make this a racial issue. Nice one. Bipartisan opposition as well. But yes, this is favoring powerful companies against the average citizens.
Yes, it absolutely would create a two-tier system, at least a two-tier system, because the reading rooms that the SDOs have established and that this legislation would in essence bless typically involve access that just doesn't make sense in 2026.
Correct.
The fact that these standards, you can't download them, you can't cut and paste them, makes it much, much more difficult to use. So just having a PDF online really is not access.
Sure, you can access the law. Just give us your personal information and agree to the terms of service. And you'd better not copy it anywhere. As bogus as copyright is at the best of times, this is the worst of the worst. Because we're talking about people with guns pointing at them. Every law is backed up sooner or later by people with guns. When you're talking about the law, it is inexcusable to not let us have free access to it. Throughout the softballing, they talked about balance. They used that word dozens of times, a balance between the public's right to know the law and their profits. But there is no balance when it comes to pointing guns at people. There is no compromise there. If you're gonna point a gun at someone and say, do what we say or else, we at least need to know what it is you say. Once again, the bill is the opposite of what they claim. They do not need to protect public access to the law because the courts have already recognized that we have access to the law. The only purpose of this is to massively restrict that access and extend ownership of the law itself to their crony organizations. Secret laws created by government-favored businesses is literal fascism.